You may do what you go.
Right. All right, ladies and gentlemen, I'm Judge Tammy Long Hayward. This is the January 14th, 2026 civil calendar. So we'll have a variety of things on this calendar. I'm going to call the calendar and we'll proceed in the order that I believe to be most efficient. So please be patient. The first name on the calendar, first case is case 2025 CV 04258. That's Viola Hogan versus Clayton County. Are the parties here for Hogan v. Clayton County?
Good morning, Your Honor. I represent Clayton County and Clayton County Board of Commissioners.
All right. Ali Subsavari.
I am Venus Esfandiari. I just filed my notice of appearance, of entry of appearance last night. I'm the associate on the case.
Okay. All right. And who's here on behalf of Ms. Hogan? Have you heard from plaintiff's counsel?
I have not.
Bryce Durham, Keota Reed. I see Ms. Reed is present. Ms. Reed, Keota Reed. Okay, the next case on the calendar is Prestige Financial Services versus Latoya Knox.
Good morning, Your Honor. Joel Schneider for Prestige.
I'm sorry, Your Honor. Can you hear me?
I hear you.
Okay, sorry about that. I was having some.
All right. Is there anyone here on behalf of Knox?
Yes, I'm here, Latoya Knox.
All right. Next on the calendar is First Portfolio Venture versus Jessica Johnson. First Portfolio Venture.
Jessica Johnson, I'm here.
Yes. Good morning, Your Honor. Good morning, Judge Hayward. Attorney Joe Pippin here for plaintiff on that one. Thank you.
LVNV Funding LLC versus Montavious Coggins and Faith Staffing Agency.
Good morning, Your Honor. This is Montavious Coggins.
Anyone here on behalf of Faith Staffing Agency or LVNV Funding? Okay. Valor Homes versus Shoshana Moore or Rodney Brown. Valor Homes.
Moore and Rodney Brown here.
All right. Isaiah Thomas versus Clayton County Schools.
Good morning, Your Honor. Ryan Eisenberg on behalf of Plaintiff Isaiah Thomas.
Good morning, Judge David Yonker and Ethan Jeanette here on behalf of Defendant Clayton County School District.
GNI IX Citizens Parkway LLC versus Loud Enterprises.
This case was dismissed.
Okay. Wells Fargo Bank versus Rasul Fall.
Good morning, Your Honor. Paresh Maharaj for the plaintiff on that one.
Good morning, Your Honor. I am Rasul Fall.
Okay. Velocity Investments versus Demetrius King.
Yes, Judge. Joe Pippin here for plaintiff on that one as well. Thank you.
Anyone here on behalf of King? All right. Let's go ahead and take Velocity Investments. Mr. King does not have has not appeared. It appears that this is going to be a default.
See him, Judge. I'm not sure what's
Wait a
with
minute.
him.
I see him. Mr. King? Okay, he's waving his hands. Mr. King, I can't hear a thing you're saying, but if you'll hold on a second, I might be able to help you. All right. So the first thing you need to do is look for what looks like an old-fashioned microphone on your screen. It'll have an up arrow. Click on the up arrow, and it'll allow you to adjust your audio and your microphone. Otherwise, the thing that might work is if you log out and come back in. When you log out and come back in, you choose device audio or computer audio, and that should assist you. All right, well, let's start from the top. Hogan versus Clayton County, Georgia.
Good morning, Your Honor.
Good morning.
May it please the court. My name is Kilter Reed. I'm appearing on behalf of plaintiff Viola Hogan. This is a Rule 12 motion to dismiss under OCGA 91112B6. All well-pled allegations must be taken as true and construed in light most favorable to the plaintiff. The issue at this stage is not whether the county will ultimately prevail, but whether Ms. Hogan has alleged facts which, if proven, would entitle her to relief. This case arises from a dangerous condition at the exit of a public recreation facility owned, operated, and controlled by Clayton County. Ms. Hogan is a senior citizen who was using a walker when it became caught in unsecured carpet at the exit door, causing her to fall and suffer serious injury. The county asked this court to dismiss this case before discovery, before producing any insurance information, and before plaintiff has had any opportunity to determine whether sovereign immunity has been waived. That is premature and contrary to Georgia law. The Georgia Constitution expressly allows waiver of sovereign immunity, and OCGA 33-2451 provides that a county waives immunity to the extent it has purchased liability insurance. The existence and scope of that insurance is uniquely within the county's control. Plaintiff cannot be required to prove waiver before being allowed discovery into whether waiver exists. Further, this case does not involve a discretionary policy decision. It involves routine, day-to-day safety maintenance. While counties do not fall under OCGA 3633-1, the ministerial versus discretionary analysis is the same across all Georgia governmental immunity law. The Georgia Supreme Court has defined a ministerial act as one that is simple, absolute, and definite, arising under conditions admitted or proved to exist and requiring merely the execution of a specific duty. That definition comes directly from McDowell v. Smith. Applying that definition here, securing carpet at an exit door, maintaining walking surfaces, and keeping exits safe are not policy decisions. They are not discretionary. They are routine ministerial safety functions. This case is not about governmental planning. It is about a failure to perform basic safety maintenance at a public exit.
All right.
Good morning, Your Honor. I represent Clayton County and Clayton County Board of Commissioners. We are here today on defendant's motion to dismiss. As Ms. Reed alleged, Ms. Viola Hogan alleges that on or around July 7th, 2023, she visited the Lake Spivey Recreation Center, a facility located in Clayton County, Georgia. She alleges that as she was exiting the facility, her walker got caught on the carpet near the revolving door, causing her to fall and get injured. Plaintiff now brings claims of negligence, negligent maintenance, negligence per se, and Respondeat Superior against Clayton County and Clayton County Board of Commissioners. Dismissal of plaintiff's complaint is warranted at the outset based on two grounds. One, Clayton County Board of Commissioners is not an entity capable of being sued. Two, Clayton County has sovereign immunity on plaintiff's state law claims. These two grounds give this court ample basis to grant the pending motion to dismiss. And I'll address both of these arguments in turn. First, Clayton County Board of Commissioners is not an entity capable of being sued. The law is well settled in Georgia that absent a special act by the General Assembly, non-legal entities such as school boards and departments of local governments are not entities with the capacity to be sued. This is demonstrated in Cook v. Colquitt County Board of Education, where the court affirmed dismissal of the board on the ground that the County Board of Education was not a legal entity capable of being sued. This is also demonstrated in Brownlee v. Dalton Board of Water, Light, and Sinking Fund Commissioners, where the court affirmed that the board was not an entity capable of being sued. And as it relates specifically to the Board of Commissioners, there is no special act of the General Assembly conferring the capacity to be sued on the Clayton County Board of Commissioners. And moreover, the court in Muhammad v. Washington Mutual FA stated, albeit in a footnote, that there is merit to the argument that the DeKalb County Board of Commissioners is not an entity capable of being sued. For these reasons, the Clayton County Board of Commissioners should be dismissed. Now, as it relates to Clayton County has sovereign immunity on plaintiff state law claims. It is well settled that only an act of the General Assembly can operate as a waiver to the county's entitlement to sovereign immunity. This is outlined in Georgia Statute 3614, which specifically states that the county is not liable to suit for any cause of action unless made so by statute. Now, the General Assembly has waived the sovereign immunity of counties in very limited circumstances, such as for claims arising by reason of the negligent use of a covered motor vehicle, which is outlined in statutes 332451 and 3692-2, which are the statutes that plaintiff relies on to allege that there has been a waiver. However, in this case, there is no claim of the negligent use of a covered motor vehicle, but rather just a claim of negligence, negligent maintenance, and negligent per se in a premises liability context, as well as Respondeat Superior, based on an incident where plaintiff's walker got caught in the carpet in the facility, causing her to fall and injure herself. These statutes 332451 and 3692-2 only operate as a waiver to sovereign immunity for the negligent use of a motor vehicle, which does not apply to this case. And even taking plaintiff's allegations as true, the Georgia Supreme Court has applied sovereign immunity to bar claims arising from slip and fall injuries that occur on a county premise. This is outlined in Wilmoth v. Henry County, where the court held that the county's sovereign immunity barred claims and actions for slip and fall cases in a courthouse. This is also demonstrated in Revels v. Tift County, where, again, the court found that the county's sovereign immunity barred claims in action for slip and fall at a courthouse. And to address the purchase of liability, the purchase of liability insurance is not relevant it's only relevant in the context of the negligent use of a covered motor vehicle. And let's see if I can, which is simply not the case here. And for these reasons, plaintiff's claims do not fall under any statutory waiver of the county's entitlement to sovereign immunity, and plaintiff's complaint must be dismissed as against the county as well.
All right, Ms. Reed, so the Board of Commissioners, from my understanding of the law, is not an entity capable of being sued. Is this something that you all can concede?
Yes, Your Honor, we concede to that, and we have no problem dismissing the Clayton County Board of Commissioners and going after the true.
All right, and is there any indication that you have in the case law that even if the county purchased insurance to cover the facilities in case of a slip and fall, that would be a waiver of, because you're asking the court to extend the doctrine that covers motor vehicles and the purchase of insurance to cover motor vehicle accidents. You're asking me to extend that to the possibility that the county purchased insurance to cover any other negligence or liability issues that may extend to the building. Is there any case law or statutory law that you have that has made such an extension in the past of the law?
So, Your Honor, the defense, they rely on Wilmeth and Henry County and Revels v. Tiff County. Your Honor, Wilmeth and Revels involved traditional governmental buildings and did not involve allegations of negligent maintenance of a known hazard in a public recreation facility. This case involves unsecured carpet at a public exit, an actively maintained condition. It's not a passive defect. Those cases do not stand for the proposition that counties can ignore dangerous conditions and escape liability as a matter of law. Sovereign immunity may be waived under OCGA 332451. A county waives immunity to the extent it has purchased liability insurance. The county has not produced this insurance information, and plaintiff is entitled to discovery on that issue before immunity can be conclusively determined.
So you basically basing this on the possibility that they may have some insurance, but what you're not telling me is that even if they have insurance, the waiver of sovereign immunity has that there's some case in the past or some statute that covers just the mere purchase of insurance being a waiver outside the motor vehicle exception.
Well, outside of the motor vehicle exception, there is a waiver, and it's determined based on if it is a discretionary act versus a ministerial act. So sovereign immunity normally typically only applies to things of the government that are of a discretionary act, such as public planning, and things of that nature, decision-making, policy-making. This is not a discretionary act. This is a ministerial act. And case law in Georgia has consistently held that ministerial acts are not covered under sovereign immunity. And the protection of and making sure that the carpet is well kept at a public recreational facility so that injuries don't happen is a ministerial act for which sovereign immunity does not apply in this situation.
All right. So how do you respond to Ms. Reed's argument about the ministerial versus the discretionary acts?
Yes, Your Honor. I will address that right now. So in the plaintiff's complaint, amended complaint, paragraph 7, plaintiff relies on OCGA 3633-1 to arguing for this ministerial act negligently performed or discretionary acts with willfulness, malice, corruption, or when their power or discretion is being manifestly abused to the oppression of the citizen. Well, 3633-1 applies to municipal corporations, and municipal corporations under this title does not refer to the counties. It refers to the cities. It refers to cities. It does not refer to counties. And this is outlined in 36. I'm going to give you the actual statute that defines. So in 3631, municipal corporations are defined as the city, town, municipality, or village. And it does not include the county, which is what the plaintiff relies on to argue for the ministerial versus discretionary acts. Also, I want to emphasize that the reliance on statute 332451 is misplaced. That statute specifically applies to the negligent use of a covered motor vehicle, which again is not at issue in this case. That's my response. Thank you.
All right. So we will make a decision based on both your briefs and your argument, and we will get that decision out to you. Is there anything else I need to hear before we adjourn this case?
Not for me, Your Honor. Thank you.
All right. All right. Thank you very much. I look forward to seeing you both before me again.
Thank you.
All right. You're excused at this time.
Okay, thank you, Your Honor.
All right, the next case is Prestige versus Knox.
Good morning, Your Honor.
Good morning.
All right. All right, so this is Prestige Financial Services versus Latoya Shantae Knox. So Ms. Knox is contending that she did not receive service. So Ms. Knox, when someone initiates a lawsuit, they have the responsibility of making sure that the person on the other side of the lawsuit is served either through personal service or notorious service. And then if they can't achieve that, there are other means by which service can be made. But personal service would mean that they came to you and they handed you the document in your hand. Notorious service would mean they went to your known place of residence and handed it to someone who was a responsible adult who could then give you the information. In this case, let's see. Right. Is this Mr. Jeffrey? No, Mr. Schneider.
Yes, Your Honor.
Okay. So Mr. Schneider, go ahead and tell me how service was perfected in this case.
It was notorious service, Your Honor. The process server went to the address that was listed in the complaint. It's also listed in the affidavit of service, 7,000 Chimney Ridge, and the person identified themselves as, they wouldn't give their first name. It was only last name of Knox. It was an adult male. They identified themselves as a co-resident, and the process server handed them summons and complaint.
Okay. And what date was this?
This was, Your Honor, sorry, July 20th of 2024. That's when it was filed. I'm sorry. Then it was
the return of service.
Yes.
All right. So, Ms. Knox, I'm going to swear you in because the presumption that service has been done the correct way is a rebuttable presumption, which means that if you have evidence that the court can take into account that would say that this wasn't the person, this wasn't your home, any of those things, there's a possible way to rebut the presumption that service was done correctly, but you would have to have that information to present. So raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do.
All right. Okay. So you've heard the information that Mr. Schneider provided about the service in this case. Tell me what would rebut that service information.
So I have a few things. One, I first found out about this July of this year, 2025, through my job when they sent me the garnishment paperwork, and that's how I printed it out. On the paperwork that I went over and seen, I seen that it was back in became default August 19, 2024. And I seen that they're saying that I was served on the 22nd day of October 2024 through depositing a true copy of the same in the mail, postage, affixed, and the address that they have on this paper from them is the address is 700 Chimney Ridge Drive, Riverdale, Georgia, 30296. Now, that was one of the family homes from my dad, and I did live there for a short period of time. But I was gone at the end of the year 2023. I was there momentarily, single parent, getting back on my feet, which is
So
the will for
do you have anything that indicates that your residence changed at a particular time?
Yes, I have my lease agreement that says that I was that says that, let me read verbatim, I shall take possession of the premises before the start of the lease term on January 11th, 2024. And I also have the signature of the lease that it was signed on January the 15th, 2024, along with my landlord information. And I've been here as of current. I have also utility bills, anything, all the service was switched over, everything beginning of 2024. I've been here. I have not had any reason to go back to the other location. Yes, there was family there. I don't know who's in that location there or anything. Like I said, I was in that situation temporarily. Unfortunately, get back on my feet as a single mother, and I've been gone and I haven't looked back. When I seen and looked up all this and was gathering information, trying to file the motion to vacate the judgment because I was improperly served. I seen on one of the documents that it said that they served, they said I don't know, a man, I don't know, what did it say? That he put
So
out 5 or
what
something.
Mr. Schneider just notated was that it was an adult male who said that his last name was Knox.
And I have no idea who's applying to, because I didn't receive any notification, anything, nothing. First time I became aware of this was 2025, right before my job, to let me know that my next pay period will be garnished.
Okay. Do you have the utility bills?
Yes, ma'am. I have Greystone. I have Greystone Connect because that's also my utility with the lights and my Wi-Fi Connect for my job. I also have GFL, which is the trash disposal company. I also have the Terminex when I first moved in here because it's an older house built before 1978. I have that bill because I had to get it serviced. I also have the hard wiring bill from Hammer because there was old house, not a lot of wiring, had to get that done. I have that service as well. And let me think, do I have anything else?
Okay, what's the date of when did you start your service with Greystone Connect?
Ooh, I would have to look up my account, but I started it January and it was fully running by the time I moved in, which is why, even though I had possession of the property January 11th, officially the lease and me moving in didn't sign till January 15th because of the light service, them trying to put the services and rewire. But I would have to get the actual date of when it started, beginning of the year.
So you said you have Terminex. Was that a one-time service?
I had it for a few months. The service and package that I got was for them to come and put down the Terminex weldings around the property and the ground to stop that corrosion. And they
Do you
made
have an invoice or bill from that?
Yes, ma'am, I do, because they also checked the roof, the insulation, told me what I needed to move forward for the winter.
Okay. Mr. Schneider, do you have any questions?
I would, not that it matters if her documents really show that she actually moved in January of 2024, but in her motion to set aside, she states she hadn't lived in the address that we served, who stated that, they were her co-resident since 2023, August 2023. So there's like a 4-month gap. And I mean, if we could see these documents as well, that would be great too, because we haven't seen anything.
Okay. I don't know how you share a screen. Do you have a phone? Are you on your phone?
I can blur it. Let me do no background. Let me see if that works. And then what I can do, I'm at my desk. I'm sorry. Let me put my keyboard back. And what I'm going to do is just turn this thing around. And let me see. First, I would do the lease agreement. I don't know if that's sufficient to where you see the actual date. And then down here at the bottom, it shows when I actually take possession of it, the property, landlord information.
One second. You don't have anything like your social security number or anything on there, do you?
Oh, you know what? Yes, let me make sure it's not in.
Yeah, cover that for me.
Just 1 minute. Let's see. Okay. No, this very first page, I don't see any
Okay.
Personal identifiable information.
Can you go to the last page where the signatures are?
Absolutely.
Okay, January 15, 2024. Is that Belinda Baker? Is your landlord? Yeah. All right. Can you go to the, I guess, the Terminex bill or the Greystone Connect bill? And if you have any identifying information for accounts or anything like that, kind of blur it out or how, like put a piece of paper over it.
I'm gonna just pull out.
Got it. If you have a post-it note, those usually work.
A post-it note?
Yeah, just to cover. I don't want, so I'm highlighting this so Mr. Schneider can see it. What I don't want is somebody who's watching to be able to get any of your personal information that's not necessary for the case.
I'm trying to find, I have several of the notices and my utility bills. I'm just trying to find the earlier ones in 2024 versus the one of this year. Any of them this year? And I think they are in the letter holder. Okay. Mm-hmm. You know what? It may be easier if I just go online to my account versus finding the hard copy.
Okay.
Just for the sake of time, possibly. Make sure. Okay, so here's one. Let me make sure. So this, sorry, that's my work alarm. So this is one, and it states it was August 9th, 2024, to show that it was in that year, and this is Greystone Power. So I'm just gonna block this out. But if you can see, Greystone Power also have their corporation, the number.
I see the numbers. I don't see the date.
Sorry, let me do it a little better. Oh, the date ain't over there. It's over there. You see how much I had to do.
Okay.
What's the date on there?
I still don't see the date. It just says the amount.
Okay.
Can you point? Okay.
Right there. You see, I'm gonna go close.
Let's say August or June of 2024.
Turn this camera around because maybe that still works best in my favor.
Yeah, that's fine.
Let me do it this way. You see?
Yeah, so that's August of 2024.
Yes.
Yep.
So that's one, just to show that it was in, that year. A little more accurate. And then I also have, this is the Terminex.
Okay.
These are the ones I haven't opened, but I can open it.
So, Ms. Knox, the appropriate, I guess, response from the court would not be to, it would be to, I guess, vacate the judgment to open default to allow, so not to get rid of the case, but to vacate the judgment to allow you to participate in the litigation.
Yes, ma'am.
So, Mr. Schneider, did you have anything at this time?
Just to confirm Ms. Knox's address, current address. Is it 9515 Rivertown Road in Fairburn? Is that what I saw?
Yes, Georgia 30213. And I've also notated it's on Google website as well with their company. The GPS pin is not accurate. Whenever you mail something, it is not going to come here. It's going to go to neighboring houses and then work my way to me. That's just unfortunate being down here, but that is not the accurate pin on Google. Is 3 houses over. So just so you're aware of that, and even with the service, because I've put the complaint in several times, and like I said, it's on their website and with their corporation of me making the complaint.
Okay.
All right, so the court is going to vacate the judgment for the purpose of opening default to allow you to participate in the lawsuit. You have the judgment, the complaint is on file. So we will get out orders to you. Okay?
Yes, ma'am. May I ask a question?
Yes, ma'am.
Now the thing with my job, and I've been going back and forth with their litigation team. They basically can't, because
well, actually, it is the since you never received the complaint, then I can vacate the judgment. But yeah, once I vacate the judgment, your job can't continue to take money out on a garnishment because there's no judgment.
Okay.
So once you get the paperwork about the judgment being vacated, you can take that to your job.
Okay, so I still have to wait to receive that documentation to submit.
Yeah, I got to put everything in writing.
Okay. Thank you.
All right.
And just to make note, Judge, Ms. Knox, it is your responsibility to update your address with the clerk's office so that we can also send you proper service of the ongoings in the case.
May I get the address? Because when I filed the motion, I did have to go to the Fulton and Clayton. Which address?
Let me ask you this. When you filed the motion, you have your current address on that motion?
Yes, ma'am. The 9515, and that's how they served me this court.
Okay, that's where we'll send the order, and that's what the clerk's office should have.
Okay.
Yeah.
And
just to make, I'm sorry, Judge, to update you, the clerk's office does not update your address just because you put an updated address on your motion. So it is still your responsibility to update your address with the clerk's office. We can take care of it from our end on what we send out, but they do not have your correct address on file.
Okay.
Okay.
Yeah. Okay. I need to go today. Is that something I need to do?
No, that's not a today thing. We have your address, so we'll send the order to where the address on the motion. I'm just saying that for anything else that you might receive from the clerk's office, like court notices, your actual address needs to be in the clerk's files.
Okay. Thank you. And I'm sorry, one more question. Regarding the money that's already been taken, that's already been garnished, once I give that order to them, can they hold that? Because technically we still have to,
you can ask them to do that if you want to. If they're willing to do that, that's fine with me.
Because otherwise, regardless of what the judge,
it's going to be back and forth, and you want to avoid that. Okay. Yeah, you can ask them to do that if you wish.
Okay. Because otherwise they will try to just repay it, or they just don't.
Well, if they took it out, they need to repay it because there's been no order from the court to forward that money to Prestige. Okay. So anything that the garnishee, this is how it works. Anything that the garnishee collects, they have to forward that money from what they collect. But I don't know if they've forwarded to the clerk's office, forwarded it to Prestige. I don't know where the money is. If they're still holding it, then you can have a conversation with them.
They send it Prestige. It's on my E&L statements, and they've shown it that it's actually being deducted and they've received it. Okay.
I'd have to check on that, Your Honor.
So just ask. Yeah.
I don't know that that's accurate. I think the garnishment court was stayed. I don't know that they actually sent any payments yet, so I can confirm it.
I do my payments. I do have the allocation, the payment stuff, because I have 3 different financial.
Okay, so it just might be with the garnishee. They may just be holding it because they're not sure what to do. They may not have sent it out. They may just be holding on to it. So once you get the order from the court, you can have that discussion with them.
And I'm sorry, one more question, Judge. That's it.
Yes,
When
ma'am.
even because I know that the laws are a little different when the government was shut down, and when I was back and forth with the furlough and working and having to be essential or not, they were still doing the garnishment even when we got the final confirmation that hey, you will get paid, but it's the back. Do I even get that back? Because I know we don't get a bonus from that because of that loop error with the government. So because all that happened during that time, is this included? Because they are.
So, Ms. Knox, I do garnishments reluctantly just because they're part of my job. And I do my best to, every time I do a garnishment, I really have to go back to the books and like look everything up and make sure I'm doing it the right way because it's not something in my wheelhouse. Anything with numbers and calculations and maximums and stuff, I'm going back to the starting point every single time. So I can't tell you anything about how garnishments work in general for things like that.
Thank you. I appreciate
All right, and I don't want to mislead you. I can't do that. All right, so you're free to go at this time, and we'll go ahead and send out that order. Okay.
Judge, on the record, the next step is that discovery begins for the parties, correct?
No, hold on a second. Let me see how I craft the order.
Okay.
All right. The next is First Portfolio versus Johnson.
Yes, Your Honor. Joe Pippin here for plaintiff. Thank you.
Jessica Johnson here.
All right, Ms. Johnson, can I see you?
Is it showing? No.
Yes.
Okay.
Oh, just one second.
Ma'am.
All right. Next, First Portfolio versus Johnson. So this is an account. My understanding is there's been a default because there was no answer file, and Ms. Johnson, they're going to present the amounts that are due and owing. And then if you have anything that would change the amount because you've made payments and you can show evidence of those payments, then that might adjust the judgment that the court would allow.
Okay.
All right. Mr. Pippin?
Yes, thank you, Your Honor. May it please the court. Joe Pippin here for plaintiff. And correct me if I'm wrong, Your Honor. I thought this was defendant's motion to vacate the judgment. And maybe I'm wrong, but that's what my notes. I believe she filed a motion to vacate, which obviously plaintiff is opposed to.
All right. So, Miss, I had I was thinking about vacate. This one. Ms. Johnson, what is the basis of your motion to vacate?
Okay, so when I first originally received the summons, it was like towards the end of October, and I was in the process of finding somewhere else to move. So like when the summons came, I really didn't I read it, but I don't think I saw like the date of like June. So I assumed that it was like old when I got it. And then after that, I didn't receive anything else because I moved to my new address. And then I recently went online to like the court document, the document site, Tyler Tech. And that's when I discovered my case was still open. So I was trying to like.
Okay, so when you received the summons, did you read it?
Yes, if I remember.
And it directs you on the summons that you have a certain amount of time to respond.
Yes, I don't have it with me now, but I thought that it said like from June, and I received it in October.
Okay, so June might have been when they filed the case, but they have a certain amount of time in which to serve you. And so if it said June, that's probably when they filed the case, but they were serving you and you had a certain number of days to respond in an answer. Did you do that?
No, ma'am.
Okay, then I have to deny your motion to vacate because you did not file an answer. You admit receiving the summons and complaint, but you didn't file an answer. And the reason that cases are initiated with a summons and complaint, well, the complaint is the specific part of it. That's the part that tells you exactly what they're saying you did or didn't do. The summons is the general part that everybody gets. And the summons tells you what court it's in, what the name of the suit is, and the fact that you're being sued and you have a certain amount of time to respond to the lawsuit.
Okay.
And so it's very important if you receive summons, you have your deadline starts running at the time you get it. So if you don't read it and follow the instructions, then you find yourself in default.
Okay.
All right.
Um,
All right.
And Your Honor, if I may,
Yes.
I also would note that I was looking over. It looks like it was default judgment from here in Clayton State, and perhaps that may be because Miss Johnson changed addresses. And while I'm sympathetic, one has to update the court of any changes of address, because if she didn't get notice to appear in person at the hearing, and she hadn't answered, so it was already in default status. But had she appeared, perhaps a consent could have been worked out. And if she changed addresses, and the court obviously didn't know that.
Well,
And
it's
so,
really not about her address. If she says she received the summons, but she never filed an answer,
yes, ma'am.
she had all the information she needed at the point where she received the summons.
I agree, Judge. I just didn't know if that was part of the argument. But without giving Miss Johnson legal advice, I would strongly encourage her to reach out to the firm, and perhaps try to work out a payment arrangement in lieu of garnishment. They probably would be willing to speak with her and work something out.
Yeah. Do you, Ms. Johnson, other than the notice you got for court today, you said you were able to go on Tyler and see the documents in the case?
Yes, because I see there's another piece of mail that was mailed out, but it has a return service on it, so I never received that. So I don't know what that is going to be about either.
Okay, so if you go on the Tyler documents, then there's information in there where you can reach out to Mr. Pippen's client and maybe negotiate something with respect to the judgment. But the judgment is going to stand because you were actually served and you failed to respond in a timely manner.
Okay, I understand. Thank you.
All right, so we'll get this order out to you.
Thank you, Your Honor.
All right, Mr. Pippen, thank you. Next is LVNV, Coggins, and Faith. Mr. Coggins?
Yes, ma'am.
And Faith Staffing? Anyone here on behalf of the staffing company?
I don't believe so.
All right, anyone here on behalf of LVNV? All right, so it is my understanding that you have a garnishment, but you may, but I think that it is taking too much of your wages, or
yes, ma'am,
wanting to lower the percentage. Tell me about that.
So right now, as it stands, they're taking 25%, which unfortunately really puts me in a bind every month. Like they're taking $300 out of a $1,600 paycheck, so I can't really afford that. So I was asking the court to lower the garnishment to 5% or whatever the court sees fit. Just so that I'm able to still make the payments, because I'm not trying to get out of the debt that I owe. I want to pay it off, but I just want to be able to pay it off and still afford to live.
And you said it's at 25% now?
Yes, ma'am.
Okay, so the two options are, it can be 25% of your disposable earnings, so I think your net, or the remainder after subtracting 30 times the amount of the federal minimum wage. And the federal minimum wage is set at 7.25 an hour. At least that's what this one says. So we'll look at those two calculations. If we're able to lower it, we will. If not, I will put that in the order.
Yes, ma'am.
All right. And if there's some kind of hardship exception, because like I said, garnishments, I pretty much do under duress. I every time I look at one, I have to read up and discover every possible option that I have. So if there's a hardship option or anything that talks about the debt to income ratio that needs to be considered, I'll look at that also. But at this time, what I'm getting is that the 25%, they can't take more than that, but they can take up to that. All right. Okay, so we'll get an order out to you.
Okay, thank you so much.
All right, thank you, sir. All right, next is Valor Homes 100 versus Shoshana Moore and Rodney Brown.
Rodney Brown and Shoshana Moore.
All right, anyone here on behalf of Valor Homes 100?
Can't hear.
All right, Ms. Powell.
Can you hear me?
Mr. Humphrey is the attorney. He's having some slight audio issues. We can hear you better.
Oh, hi, Mr. Humphrey. How are you?
Hello, Your Honor. Can you hear me?
Yeah, good to see you.
Good to see you too, my friend. How are you?
I'm good. Mr. Humphrey and I went to college together.
Wow. Slow it down,
Yeah.
girl. See, that was last century. Let it go.
Well, see, because I look much younger than you, sir, I'm able to
See.
say it.
I'm gonna hold my tongue.
How are you doing, sir?
I'm doing well, Your Honor. I'm doing
Okay.
well.
All right. So Valor Homes versus Brown and Moore. Miss Moore and Mr. Brown are present. It appears that at the time of filing, there was a significant amount that the company was claiming was owed. So Mr. Brown, Ms. Moore, Mr. Humphreys is going to put on his presentation on behalf of Valor Homes, and then you all will be able to respond to the information that Mr. Humphreys is giving. Okay, go ahead, sir.
Excellent. Thank you, Your Honor. And may it please the court, I'm just entered my appearance on this matter about a month ago, but my understanding is that the defendants for renting property located at 628 Crestmont Court from my client, Valor Homes 100 LLC, and the lease itself began in August 1st, 2024. Payment was made in August of 2024, and no complete payment has been made since that time, although partial payments did occur in the next 2 months. As of November 1st, 2024, no payment has been made towards the lease itself. 628 Crestmont Court. The current rent is at $2,300 a month, due each and every month since the date of execution of the lease. I believe the defendants may have filed, they know that in fact they did file for bankruptcy in 2025, January. And there was a stay in the matter for a number of five months until April 29th, 2025, upon release of a mutual consent agreement signed by the parties with an order releasing my client and specifically allowing the plaintiff to continue in its eviction. That's when a representative from my client filed in the state court, because at that time in July of 2025, the total outstanding amount was $26,050. To date, the defendants, who are still occupying the premises to my knowledge, owe a total of $41,358.42. We are not asking the court for attorney's fees or any other costs, but we're also asking that we get a judgment in that amount of $41,358.42, along with an express authorization that a writ of possession to be issued pursuant to OCGA 44755 for removal of the tenant and their personal property from the premises.
Right. Who's speaking on behalf of you all, Brown or Moore?
Can you hear us?
Yeah. Okay.
Oh,
So,
okay.
it's alleged that you owe a total of $41,358.42. That since the last payment made in October of 2024, that you have failed to make any payments. While you may have filed for bankruptcy, this client was released to pursue their eviction, and at this time, the total amount owed is $41,358.42. All right. So just so you know, the law in Georgia states that if you are in possession of a property, that the rent is owed and must be paid. If there are issues like maintenance issues, once you have given notice to the landlord, if the landlord has not acted in a reasonable amount of time, then you have the opportunity to repair those things yourself or to call in someone to repair them to keep accurate records. And then you may use those amounts as offsets against the rent. But you cannot withhold rent and not pay rent as long as you're in possession of the property. So tell me what's going on.
Well, originally, ma'am, we literally have been several different things have happened to the tone of family members passing.
Okay. The
And then
hardship is not a reason for you to hold
Your Honor,
on.
I promise I'm not trying to I'm
Okay,
just
so
letting you
tell
know that's what
me,
was going on. So
yeah, I
as of
get
this
it,
moment
but
in
you
time,
rented the property and the last time you made a full payment was the first month. So, and that's been since 2024.
okay, so on that point, that information that he spoke is not accurate at all. We made the first 3 months payment, and when we moved in, we paid the first month rent and the deposit. So it was a total of $4,600 they received originally. And then after that, we did make 3 months of payments before everything began falling apart, basically.
But this time you're not able to make the payments.
No, man, we had to relocate. We did move out. We've moved most of the stuff out of the property. It's still a few things there that we're trying to get out as of now. But I've been running into issues with vehicles breaking down, which has stopped me. But I have the vehicle back up and running now. I just went over there yesterday and took a whole load of stuff out. So it's still things in the house that we're trying to get out right now. But we have moved from the property and just relocated where we can for the moment. But
So here's the
which
issue about moving from the property.
mhm.
As long as you have not vacated the property and turned the key back in to the landlord or to let the landlord know that we're no longer occupying the property, as long as you have anything in the property and they don't have the ability to go in and turnkey it and relet the property, then you're still holding over and occupying the property. You haven't presented any information to permit the court to find in your favor. So at this time, the court is going to find in a judgment in the amount of $41,358.42 and grant a writ of possession. The only time I can give you is 7 days. That's what the court is allowed to do. So there's a writ of possession that will issue in 7 days. At that time, the landlord can take whatever steps are necessary and legal to go ahead and to take possession of the property.
Okay, and I was trying to get around to it, but there in my response to the court from the first time, there were several things that was going on with the property. I myself have been in communication with Mr. Alimo, which is I believe the owner of Valor Homes, from my understanding, and he understands that I am like getting out the property and things of that nature. So we have been in contact. Well, I understand what you have to do is what you have to do. I'm not trying to overstep or sidestep anything. I just wanted to make sure everybody understood it wasn't like we were trying to live there for free. Basically, that's all I was trying to say.
I hate to say it, Mr. Brown, but you've been there for free for 2 years.
And that was the amounts that they're saying is incorrect. And like I said, we did have me and Mr. Limo have definitely had more than one conversation about that. So, but I do understand, like, if that's what they're saying, I would have to go and do my own calculations. I did not do that before court today. So I do apologize for that on my side. That's me not being prepared on that side. But I'm just about sure that the amount is not 41,000.
All right. At this time, Mr. Humphreys, would you be willing to do the order and send that in to Ms. Powell, who's my staff attorney? I can't hear you. You're muted.
My apologies, Your Honor. Yes, I will draft the order and have it sent in. If I can get the actual correct email
Ms. Powell, go
correspondence.
ahead and chat Mr. Humphreys your email.
Excellent. Excellent.
Yes.
Thank you very much, Your Honor.
All right. So you all need to, the court is giving you 7 days because that's what the law permits. Go ahead and make sure you get the rest of your things out of the property, and so that Mr. Humphrey's client can enter the property. Okay.
Yes, ma'am. And I'll make sure we turn the keys in and everything now. Thank you.
All right. Thank
Thank
you.
you very much, Ms. Moore and Mr. Brown. Thank you. And thank you, Your Honor, for your time.
All right. Take care, Mr. Humphreys.
Thank you,
Good
Mr.
to see
Powell.
you.
Take care now. Bye.
All right. Next is Thomas versus CCSP. So Isaiah Thomas versus Clayton County Public Schools.
Morning, Judge. David Yonker here on behalf of defendant Clayton County School District. Judge, this is before Your Honor on a motion to dismiss. This complaint that was brought by plaintiff in this case was related to an August 18th, 2023 incident where plaintiff alleges that he was shot in the parking lot of Terrace Stadium. The plaintiff was a former student of Jonesboro High School, and the plaintiff alleges that he was attending that game, even though he was no longer a current student, that as a former student, he had an interest in a game that was at Terrace Stadium that Jonesboro High School was participating in. Plaintiff alleges that in the parking lot after plaintiff was leaving, there was some sort of attempted robbery, and then ultimately he was shot by an unknown assailant in the parking lot. And this incident wasn't in the stadium when it occurred, but he's suing the Clayton County School District and did so on July the 3rd of 2025. We're here on a motion to dismiss that was timely filed in this case for 2 grounds under sovereign immunity, no subject matter jurisdiction under OCGA 9-11-12B1, and then also failure to state an actionable claim underneath subsection 6 as well of that same statute. In this case, the claims that were brought by plaintiff are barred underneath the Georgia Constitution. To be honest, Judge, there's no real disagreement between the parties as to the alleged facts in terms of the consideration for Your Honor. And to plaintiff's credit, I think we were able to very much narrow them in the pleadings. So there's no disagreement as to the allegation of the facts. There's also no disagreement between the parties about the general existence of sovereign immunity under the Georgia Constitution and that it should be considered in this case. The disagreement in this case is that plaintiff counsel believes that there is some amount of interpretation of that would allow this case. So in response, the defendant would say that the plaintiff is asking this court to ignore the Georgia Constitution and the provision that's inside of it. This is your prototypical case for sovereign immunity in that it's a claim directly against a school district, and as such would be barred by sovereign immunity because the school district can't be sued underneath this cause of action. And so while plaintiff is stating that the lawsuit should move forward under interpretation of application of sovereign immunity. In this case, it's not about application. The district just can't be sued. It's not possible to be sued in this case. And the plaintiff says that the court should interpret the scope of that sovereign immunity, but it can't ignore a constitutional requirement. This is a constitutional requirement. It applies. Plaintiff says it should not apply as it would not be the will of the people, I believe is the phrase that plaintiff used in his brief. But as it is,
public policy argument?
It was generally speaking, yes, Judge, a public policy argument that basically sovereign immunity was a leftover of common law defending the king, and that it shouldn't be allowed in this kind of case as it's not an appropriate will of the people. However, as it is part of the Constitution, it is the law, and obviously the Constitution was adopted both by the people and by their representatives in the state. So if, unfortunately for plaintiff, if he wishes a different application of sovereign immunity or a different scope of it, as he noted in his brief, it's been changed several times since it originally was adopted. The appropriate route for that would be the legislature, not this court. As such, the facts in this matter do not require an analysis as much as the fact that the district cannot be sued with this type of claim. And while obviously the injuries that are alleged by plaintiff in this case, the defendant feels bad that plaintiff is injured and that is in the condition that he's in, while there is a general understanding and feeling as to that, there is no subject matter jurisdiction. There are no claims presented that can be valid underneath either the subject matter or the 12b6 provision. And as such, we would ask that this case be dismissed.
All right.
I largely agree with my friend's position. And I don't think the court probably needs to spend a whole lot of time on the analysis. Where I guess I would just differ for purposes of proceeding in terms of maybe depending on how you want to enter an order. I don't think we're making a public policy argument. The argument that we're making is that Terra Stadium is operated by the school district as a for-profit business, and that it is not on school grounds. It is available for anybody to lease it, which is effectively what has happened that we've alleged in this case. And that, so while I concede that the literal language and the relevant constitutional clause says that you can't sue a school district, period, I don't actually think that that's, and maybe the answer is the court or the courts, the appellate courts or the Georgia Supreme Court may say, we'll take it up with the legislature or get a constitutional amendment.
Well,
But
Mr. Eisenberg, so it sounds like you're asking for a new law or an extension of a law that doesn't apply to this particular context. So this is my question. Unfortunately, Mr. Thomas is not the first person to be shot in the parking lot of a school event. So is there any case law that supports your argument in this case?
so I'm going to tell you, first of all, I think you should, and if I were you, I would grant their motion, right? I don't think you are in a position not to. I do think, however, that actually none of the cases talk about the application. All of the cases are about waiver. And my argument is this is a problem, and this is the argument that I want to present to the appellate courts is if in fact the literal interpretation is applied in this context, then there's nothing stopping any school district in the state from operating any business for profit. And if that's what the courts think that the law means, that the sovereign immunity provision means, then I want them to say so. Then we can figure out, one, how to get it changed, or we can solve school funding problems because they can operate businesses at will and lessen the tax burden. None of those are issues that I'm going to take up with you. I did raise those arguments in the motion because those are the points that I want to be able to make to the Court of Appeals or Supreme Court.
I agree with you. I think this is not within my purview to extend the law in the way that you are asking. So I'm going to do what you both agree I should do. But this is the other question that I have. When you say for profit, but when being a mama who goes to sporting events, I can't imagine that they're making a whole lot and they're probably just barely covering cost. So does the distinction rest on for profit, or does the distinction rest that the Terra Stadium can be used for anyone and it's not the school does not have exclusive use of that property.
So it's really that they're operating, and I don't know what the profitability is. I also had kids in school, although they're gone now. I can tell you that, there were some instances where, I don't know if you have had the opportunity to make donations to athletic, associations or the booster things or other things that go on in the, I don't know. I don't think the motive isn't to make profit to distribute. Um, I think my argument is not that they don't have exclusive control. And I do think this case would be different if it were on school grounds. So I'm not sure I want to divorce both of those issues completely, but it's not school property, and our allegation is it is being operated as may not make much money, may not make any money, as a business. And our position is, given those circumstances, it should be treated like a business, and that none of the
sovereign immunity.
And that's where that it is not an exception. That what I propose is that despite the literal language that school districts can't be sued, I don't think that that's a reasonable interpretation of what that means. And I want an opportunity to present that argument above.
All right. So we'll go ahead and make everybody happy. We'll get an order out to you. And then we'll follow the case and see what happens at those wiser, scholarly individuals downtown.
Thank you so much,
gentlemen. It's been a pleasure.
Thank you.
Okay, the next case on the calendar is Wells Fargo versus Fall.
Hello, Your Honor. Praise Maharaj for the plaintiff on that one.
All right. Your audio's a little mushy.
Oh, mine?
Hold on a second. Maybe I got two people talking at the same time. So, Mr. Fall, it is extremely important that you pull over and be stationary for the hearing. I can't have you operating a big rig and jeopardizing folks' lives on the road through inattention. So when you are settled, let me know.
Yes, Your Honor, I'm settled.
All right. So this is Wells Fargo Bank North America versus Rasul Fall. This is a post-judgment proceeding, and the defendant is moving to open default because he failed to receive service. So, Mr. Fall, okay. I'm not sure if you saw the previous case, but the service is what we call a rebuttable presumption. So once the plaintiff files the return of service that you have been served, they file a document with the court saying, hey, this is how the person was served and this is how I served them. This is when I served them. At that point, the court takes it as a given that the service has been perfected. If you, however, believe you haven't been served or properly served, then you can rebut that presumption by putting in evidence that you were not served per the information given. So raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand down. Okay, so Mr. Maharaj, do you have the information from the return of service?
Yes, I do, Your Honor. It's the return of service in this particular case
14 minutes via Ronald Reagan Memorial Tollway.
Okay, hold on. Somebody's I'm hearing somebody's audio. So if you're not being spoken to now, if this is not your case, please make sure that you have muted your device. For those of you who don't have your first and last name on the screen, we'll address that in a moment. But if you are not on this case, please make sure your first and last, please make sure your device is muted with the little red line through the microphone. All right, let's go.
Yes, Your Honor. So the return of service in this particular case was filed on January 14th, 2025. It does state that service was completed notoriously on January 12th, 2025. It was left at 5895 San Gabriel Lane in Atlanta. That is Clayton County. No answer was filed with the court in that time, hence our motion for default.
Okay. And Mr. Fall, so they're saying notorious service means that they took it to your house and left the information at your house with an adult who was of an age to understand that they have to communicate that information to you.
Nothing. It was not communicated to me. That's why when I opened my bank account and see my money was taken, I would say, "What's going on? Why
Okay.
my money was taken?"
Here's the question. Was this your address at the time that he says service was done?
Yeah, that's where I live.
Okay. Is there anyone, an adult who lives there with you who could have received the paperwork?
There's no adult in there. There's no adult.
In the affidavit, so there's a party named Kadimu Fall.
That's a minor. That's not adult. That's a minor.
Who is 15 years of age or older, a person of that.
Yeah, he's not. He's a minor. How you gonna sell him? He never told me anything. I never received nothing from him. That's a minor.
All right. Did they put an age down, Mr. Maharaj?
They put an age estimate that said a visual to a black-haired, black male, contact 18 to 25 years of age.
18 to 25. Okay, how old is is that your son, Mr. Fall? Okay, I can't hear you for some reason.
Yes, he's my son.
How old is he?
At that time he was 15 years old. How are you gonna be able to give me something like that? He didn't give me anything, nothing. I ain't getting nothing from him. I even know nothing about the case until I wake up one day. I want to pay my mortgage and there's no money. I want to pay my electric bill, there's no money. I want to pay my water bill, there's no money. I want to pay my gas, there's no money. I want to buy food, we don't have money.
I got you, Mr. Fall. So do you have any other people living at the house who could be this person?
I mean, not related to me.
Okay.
Yeah.
Do you have anything that indicates his age at the time of service?
Anything that indicates his age, not with me. Not with me.
Well, sir, this is your case. Why, if you have evidence, how do you not bring it on the day that you're filing the motion?
Yeah,
it's your motion.
Right, but he mentioned that there was a minor in the house that they give the paperwork. I asked my son, what is it? He said he don't know.
Okay, so here's the thing. I said it's a rebuttable presumption. So he says his person served someone who was age 18 to 25. That's what they estimate.
He's not 18, he's a minor.
Okay, but Mr. Fall, so you have to give us something that goes against that. You're the one bringing the motion. So the person bringing the motion has to have the information necessary to move the motion forward.
Okay, okay, hold on.
Also, Your Honor, I will point out that there is case law to suggest that 15 years or older is the acceptable age, is the suitable age to accept service.
All right, give me the case law.
I'll have to look that up, Your Honor.
how on my phone I have a document here. How can I give it to Your Honor?
Hold on. What's the document, Mr. Fall?
It's his passport.
Okay, is it your son's passport? The problem that I have is I don't want any of the information being put out into the universe so that somebody could steal his identity.
Right.
Um, Mr. Maharaj, do you have that information?
Not yet, Your Honor. I'm just pulling it up now. Well, I have it saved somewhere in here. It'll take me a minute.
Mr. Fall, what was the year your son was born?
2007.
I'm sorry, you said 2007?
Yes.
$18.
He was born June 2007.
What was the date of service again, Mr. Maharaj?
That would be January 12th, 2025.
Okay, so it looks like he would have been 17 at the time. Mr. Maharaj, it depends on whether you have case law that says 17 is acceptable.
Yeah, sorry, we're getting that. We'll get that to you right now, Your Honor. Just getting the citation right now. 289 GA Appellate 619. Holmes and Company of Orlando v. Carlisle. Okay, here we are. According to Georgia Code 911-4E7, an individual who is at least 15 years old is a suitable age to accept service on behalf of another resident in the same dwelling.
Okay.
If it would help, I could copy and paste the citation in the chat.
Okay.
Sorry, technical difficulties. There we go. And the name of the case is Holmes. And that's the name of the case that's being quoted.
All right. So, Mr. Fall, the service at the age of 15 is legally allowed. Not only am I taking the word of Mr. Maharaj, but I'm doing my own research. So at this time, the default will have to stand.
I mean, this how are you gonna give a kid something this serious?
Well, Mr. Fall, I don't like it, but it's what the law says.
I mean,
I
something
don't think a 15-year-old should be allowed to accept service either, but I'm looking at what the law says.
I think I should have received a certified mail with signature on it, so at least it come to my house so I can get it. Because
Okay, well,
is,
that's not what the law says, Mr. Fall.
yeah, this is something serious like this. I mean, you cannot just send a mail, give it to a kid who don't know what to do. This kid nowadays they don't have no sense of responsibility. You give them something, they don't even know where they put it at.
I
And
get
now,
you. I got
yeah,
teenagers, but
yeah.
all I can tell you is that service based on the law and the fact that your son was 17 at the time, he was of a suitable age to accept service of process.
I mean, I have an issue with them taking my money because even if the court didn't say no, taking any of my money, first of all, I lost my job during the COVID. Things have been, I'm in hardship. Things are very difficult. I've been going through a lot of stuff,
Mr. Fall, I get it. A lot of people are going through a lot of stuff. Trust me. But the law does not permit a hardship exception if you owe a debt.
But okay,
You can, Mr. Fall, you can talk to the people who you can call Wells Fargo and see if they're willing to set up a payment plan on the judgment. You can do any of those things, but the mere fact that you had hardships and weren't able to pay does not make it Wells Fargo's responsibility to just forgive or waive the debt. If you took out the money, you owe it. So with that being said, the service was proper and the judgment will stand.
I mean, I understand.
Wow.
It's a debt. I understand that. They've been adding late fees on it. It was not the whole balance. Putting
Okay,
late fees.
so sir, all of that is in the contract for for the credit card. I'm assuming it's a credit card or a personal debt. All of that is going to be in the contract.
But there was no garnishment. Why they coming in my bank and take my money? There was no garnishment on that. They shouldn't be coming in my bank and take my money. I mean, I'm not saying I don't want to pay. I'm not saying that. We can work a payment plan. I pay.
Okay.
Mr.
Fall, that's all I can do. That's all I can do. That's all that's before me. So at this time, the case is the judgment is going to stand and your motion is denied. Okay.
So are they going to give me my money back though? Whatever they hold?
Probably not. No, sir. All right. So you're free to go at this time. All right. The next case is Velocity Investment versus King.
Yes, Judge. Attorney Joe Pippin here for plaintiff. I'll be much quicker than the last hearing, I promise.
That's okay. All right. So, Mr. Pippin, and I did see Mr. Demetrius King. Mr. King. Mr. King.
Judge, Mr. King,
Can you hear me?
Okay,
I
there we
hear
go.
you.
Okay, thank you.
Okay. Okay, but Mr. King, you got two devices on.
Yeah, I was the computer was acting up, so I came back in through my phone. I was trying to make sure I get in because I've been here the whole time. Yes, ma'am.
Okay, so I'm sending you a message to turn your video on.
Okay.
Okay, it's just
So you
black.
can hear me on my computer, right?
I can hear you, but it's just black.
Camera. Okay.
There you are. All right. So, Mr. Pippin, go ahead.
Log off this phone.
Yes, Your Honor, may it please the court. Joe Pippin for plaintiff. This is on defendant's traverse, though, Judge. The plaintiff
Oh,
is
okay. I'm sorry.
obviously opposed to that. It's okay, Your Honor. I'll let him go first.
To me?
All right. So, Mr. King, what you're alleging is that the amount that's been taken out through the garnishment is incorrect?
Well, it has exceeded the judgment because this case was tried and was done in Spalding County. So I submit to you was the Spalding County judgment, and they award them like about $3,900 estimate, and they've taken out about $4,400 out my check, and I submit the check stubs as well. So I'm still wondering why we're trying to continue garnishment when from the order I received from Spalding County, it's been settled and overpaid.
All right, Mr. Pippin.
Yes, thank you, Judge. I show $4,437.56 as of today, and I believe that is the full amount. If he's wondering why it has increased, in short, Your Honor, he is correct that this was a judgment in Spalding Superior Court. $3,339 principal, $179.65 of post-judgment interest. I'm sorry, I had it written down here. Let's see.
The judge has it.
Okay, well, there was $377.29 of interest. Excuse me, that's not post-judgment, Your Honor. I'm sorry, that was awarded in Spalding at the time of judgment. The principal plus that amount of interest plus $264 in court costs. And that was on January 31st of 25, so right at a year ago. So then the cost of this action, I have so many pages in front of me, but on this summons, $277. So yes, the total claimed is $44.37.56. I'm not sure if that full amount has been taken out of Mr. King's checks,
King,
but
what do you allege has been taken out?
To me?
Yeah.
On my check stub, it said it's dated 12/13. It's the total amount from garnishment has been $43.89. But at the time of the judgment, they was only awarded a total of $3,882 from the judgment. So if I'm already got a judgment and paying it, how am I still getting interest on that?
Okay, so here's the thing. There's something called prejudgment interest, and there's post-judgment interest, both of which can apply in particular cases depending on what's owed and what's asked for. In this case, the Superior Court in Spalding County did grant interest, and that amounted to, if I'm correct, Mr. Pippin, $377.29.
correct.
So that's on top of the $3,000. And then there's court costs. And the court costs in this case were $264. Were there any other amounts awarded in the judgment?
No, those are the total three things. And that total is $3,800. Like $38.82.
So what's the underlying debt, like before the add-ons?
I'll add it up very quickly, Your Honor. It's either 38 or 39. One briefly for the court. 33.39 and 62 cents principal plus the 337.29 prejudgment interest.
I'm sorry. 377.
377.29 prejudgment interest. This was all in Spalding in the
Yes, sir.
initial order, plus 264 court costs. Again, that was all Spalding.
Yes,
So
sir.
we got 39.40 and 91 cents as of January 31st, 25, the day of judgment. So 3,900 before any filing here in Clayton or any post judgment interest. And I'm showing if it's at 4,400 inclusive of the court cost in this action, which I'm showing is $264. We add that.
So the garnishment, okay. So the $264 was for the judgment. how does the garnishment filing get added to the judgment?
Maybe I misspoke, Judge. That's what I show on the FIFA. $264 in court costs. I'm sorry, that was the underlying judgment. You're correct, Judge. Let me see.
So yeah, then he's paid and he's owed money back.
It sounds like he's either just about pay. All right, I'm showing total. This was the balance breakdown on the wage garnishment worksheet. I show 179 in addition to those amounts, the 4160.50 that we stated earlier, the prejudgment interest, the court costs, and the principal was 4160.56 out of Spalding. I show $179.65 post judgment interest. The other amount, C D E. I believe all it is, Judge, is there are no additional costs. It's just the post judgment interest accrued to date.
I have a question.
That puts it at $4,351.11.
Yes, correct, Judge.
He says he's paid 43.89.
On my check stub dated 12/13 that I submit to you already in the court filing, it's on there in my list of statements on the garnishment total.
Yeah.
Yes, ma'am.
Well, then it does sound like he's paid off.
He's paid off, and he might be owed some money back. Like
so why am I incurring new court costs for a case that was I thought was decided?
No, that's what we were talking about, is that you shouldn't be incurring new court costs. It should just be post judgment interest, which even with that, you've paid it off. So can we get a satisfaction of judgment and a return of any excess funds?
Yes, Your Honor, that's correct. And I'm sorry I misspoke. There was not other court costs. The only amount that has been added since the date of Spalding judgment was post judgment interest, and it sounds like this gentleman has already paid that off as well. I'm going off my notes. I'm sorry if for taking up everyone's time.
I have one more question.
Yes, sir.
Could you explain the post judgment interest? I know this case was settled in at a certain date, and this was paid off in my check stub is from 2025.
What date in 2025?
Oh, hold on, I got my check stubs here. Hold on, let me go back here. I got everything in front of me. So this was paid off in 2024. The last check stub was December of 2024 when this was paid off. So what other interest was accruing from the time?
Yeah, so he shouldn't have any interest from this year, Mr. Pippin.
This was paid off in December of 2024.
All right, I'm not sure what he's referring to, because the judgment I'm looking at from Spalding Superior is dated January 31st of 25.
Oh, so yeah, this wouldn't be that garnishment. You're looking for something that started after January 31st of 2025.
That sounds like he paid off something else. That's maybe the confusion there.
Well, I'm thoroughly confused now.
Oh, well then.
Do you have more than one garnishment?
This is the only garnishment I've dealt with. That's what I'm saying. I'm thoroughly confused. If this is the case, this is the case number for Spalding County, right?
Yeah.
So I don't have another garnishment that I know of. That's what I'm saying. That's what's confusing. That's why I submitted all this stuff.
Okay, and so you said the last paycheck where funds were taken out was from what date?
Hold on, I'm going to the check stub now. So this is
Jesus.
12/13/2024.
That's some other yeah, that's got to be something else.
Okay. Now I'm thoroughly confused.
Okay, so this is what we'll do.
Okay.
So Mr. Pippin and Mr. King, since none of us are on the same page, I will give you 30 days to submit like supplemental information. So
yes,
give me dates, amounts. Mr. King, I'm going to need the exact amounts taken from your check. I'm going to need pay stubs from where those were taken, and then the total garnishment. Because if the judgment wasn't granted until 2025, nothing paid before that would go to that judgment. It sounds like there's something else.
So hold on, I submitted the service date as well. So no, this gotta be the same one, because once again, okay.
Okay, but if it's the same one, let's all get on the same page.
Yes, we'll
Mr.
figure.
Pippin, because you're not
Yes.
in your office, you can figure out, once you get to your office, you can figure out what's been received, what you've received from the garnishee,
We will.
and
Yeah. Yes, Your Honor. We'll submit additional supplemental documents. I will just say for Mr. King's sake that if, as Your Honor stated, any payments taken out of 24, I know it may be confusing. I'm actually confused myself, and so I apologize. But as the court stated, this judgment was January 31st of 25, so there was no garnishment on this particular case from 2024. So that I know.
This day of November 8th, 2020. So if you look at the summons of my copy I gave you the judgment from Clayton County and plus the this right here. This has Investment LLC on it. This is the same case from 2023.
it has Velocity Investment LLC. What's the case
This
number?
is civil action. I was looking for case number. Civil action GA 237108. Attorney address Duluth, Georgia.
That doesn't sound right. So what we're looking for is something at the top of the page. On the right-hand side of the page at the top, it should have something that says file number or civil action file number.
It does. This says civil action number 23V-1030. This is Spalding County, November 3rd, 2023. This is when I was served, but it's still the Investment LLC, so I was only served one court date.
Okay, and when did your employer start taking money out of your check?
October, September, in 2024, September, October, the fall of 2024. The first check still, hold on, I got it right here. The first check still I started getting garnished was 9/13/2024. All the way to December the 13th of 2024.
Okay, and so it's a 2023 case, but the judgment wasn't signed until January of 2005, Mr. Pippin?
That's correct.
I just went and got a copy of this from the Spalding County Courthouse before I came and submitted to y'all. So that's what I was saying. That's what I just got copies and submitted them.
Okay, but did you see the copy of the judgment from Spalding County?
They printed out me a copy of the judgment when I went and asked for a copy of the judgment.
What's the date? Look on the date.
It says January 31st, 2025. That's what it says. I'm looking at.
Okay, so then you got to go back to your job and find out why they were taking money out.
Okay.
Take the judgment with you and tell them you didn't get the judgment until December 31st. Where were they taking the money and where are they sending it?
Yes, ma'am.
Okay, so you got to figure that out because they may be confused, and it just may be that you actually had a judgment, but they might have been taking money out of your check that they should have been taken out of somebody else's check.
Okay.
But yeah, the problem is going to be if they didn't get a judgment and a demand for garnishment funds that they can show you, then there's a problem with your employer.
Okay.
All right. What I'm going to do is reset this for 30 days to give you the opportunity to talk to them, get clear on your numbers, get clear where the money went.
Okay.
All right.
Thank you, Your Honor. Does the court happen to know the date and time of that?
I don't have a date right now, Mr.
That's fine.
Mr. Pippin, but I'll give you one.
That's fine. Thank you,
y'all
Your
have any
Honor.
conflicts, just let me know.
Yes, ma'am.
Quick question. So
Yes,
have they received any funds on this case? Because I'm still a little bit lost, but I know I got
Mr. Pippin, have y'all been paid at all?
I believe the court has the funds, Judge. I don't show anything received.
Usually when we release the funds, it's from a demand where y'all say funds have been placed into the court registry, we would like to have those released. But I don't go looking for them. So
Yes, ma'am.
usually y'all tell me if funds are there.
Yeah, yes, ma'am. It's completely understood, and I agree. I don't see the any release file, and I don't see it in front of me, Judge. Looking at
Okay,
these.
so I'll give you that same amount of time and then you can follow up on that
Yes,
to
ma'am.
see if the clerk's office actually has funds that are from this garnish.
Yes, ma'am.
All right, thank you.
Thank
So
you.
will that all be sent in writing?
Mr. Pimpin will put his information in writing and you will put your information in writing.
So what do I need to put in writing? I know I need to go follow up on these funds, but I'm saying like if he found out about the funds, like I said, I understand what you're saying. So what do I need to do?
Well,
Besides contact my job at the
okay,
moment.
yeah, you're gonna need to talk to HR
Okay.
or payroll, and you're
Okay.
gonna need to ask them why they were taking garnishment funds out to show you the garnishment paperwork, the
Okay.
legal paperwork that they received, and get a copy of that and get a copy of any other information they have about why they would have been taking money out and the judgment that they were going on.
Okay.
All right.
Yes,
Okay.
ma'am.
All
I
right.
understand
Thank
that.
you, sir.
Your Honor,
So
may I
like
be heard?
Yes, Mr. Swan.
Yes, ma'am. I have a hearing in Decatur at 1 o'clock today. It's an in-person hearing. I'm here on the case of Members First Credit Union versus Rodney Jones. I don't know if opposing counsel is here or not, but I probably need to leave by 12:15 to get out there. If we're not going to reach the case and the opposing counsel is not here, I would recommend that the matter be put over to the next motions calendar.
Okay, so Velocity Investment versus King is going to be continued for 30 days. And you're on the 11 o'clock calendar.
Yes, ma'am.
You are Members First. That's the second case. Rodney Jones. Is there someone here on behalf of Rodney Jones?
Yes, Your Honor. I'm attorney Jessica Ashton. I'm appearing on behalf of my colleague, Ms. Takia Thompson. I submitted a entry of appearance last night.
All right. Mr. Swan, go ahead.
Yes, ma'am. This is a motion for summary judgment based on a failure to respond to requests for admissions that were sent to opposing counsel on August 21st, 2025. No response has been made to the request for admissions or to the interrogatories or to the request for production of documents that were sent to opposing counsel at that time. OCGA section 9-11-36 provides for the prepondering of the motion or the request for production arrest for admissions, and provides in section 2 that the matter is admitted unless within 30 days after service of the request or within such shorter or longer time as the court may allow, the party to whom the request is directed serves upon the party requesting the admission a written answer or objection addressed to the matter, signed by the attorney or by the client. No response has yet been received to the request for admissions. The defendant's counsel was asked to admit that the defendant entered into an agreement with the plaintiff that there is presently due and owing the principal sum of $1789.01, that the plaintiff has requested the payment of the amount, the defendant has failed to pay the amount to the plaintiff, and finally, in the last request for admissions, the defendant is asked to admit that he's indebted to the plaintiff in the amount of $1789.01 principal, interest at 13.88% per annum from 12/16/24, and all costs of court. And we have submitted an order in judgment with the motion for summary judgment, Your Honor.
Right. So, ma'am, on behalf of Mr. Jones, why wasn't the discovery responded to?
Your Honor, I wish I had an explanation as to why discovery was not responded to. I will not deny that it does not look like it was responded to in my system. We do have a position that the original pleadings that the plaintiff submitted with this summons and complaint was defective and that he did not show adequate material to prove the amount in controversy, but I cannot sit here and deny that discovery was responded to. I don't see where it was.
Okay. With that being said, then with those things taken as if as admitted because of the lack of response to discovery, the court is in a position to grant the judgment. All right. So, Mr. Swan, if you will send over your order, the court will grant the judgment as requested.
It was submitted with the motion, Your Honor.
All right. We'll go ahead and get that order out to you, and the case will those requests for discovery having not been responded to will be deemed admitted.
Thank you,
Your
Judge.
Honor. And will we receive a copy via e-filing?
Yes, ma'am.
Thank you, Your Honor.
All right.
May we be excused, Judge?
Yes, sir. Thank you.
Thank you, and thank you for accommodating me.
No
Appreciate
problem.
it.
All right. CNF Finance versus Jennings. Ms. Capers. CNF Finance versus Jennings. Anyone here on Jennings?
Good afternoon, Your Honor.
Good afternoon. All right, so I don't have a response from Jennings. I don't, okay, who's here? Who's the iPad? Jennings. All right, so Ms. Capers?
The iPad is for Kimberly Chandler. Sorry.
Your name is Kimberly Chandler?
Yes, ma'am.
Okay, hold on.
Okay.
All right, Ms. Capers. On
Yes, Your
behalf of CNF Finance.
Oh, go ahead. I'm sorry.
No, I was asking you. Go ahead and present.
Okay, yes. So we're here, Your Honor, on plaintiff's motion for summary judgment. We instituted this lawsuit to collect the deficiency balance owed on a retail installment loan contract. The defendant was served with the lawsuit and filed an answer. And one second. And in response to that answer, we filed this motion for summary judgment stating that there's no genuine issue of material fact. It doesn't appear that they pled any admissions or denials in their particular answer. And so I didn't see any legal arguments or factual arguments that would defeat our right to summary judgment. So we just asked that the court grant the motion for the deficiency balance owed as well as court costs and attorney's fees. And I did submit a proposed order with the motion, and none of the figures have changed, and attorney's fees are pursuant to 13-111 as outlined in the contract.
Okay, how much is the amount of the judgment you're seeking?
$10,578.09 in principal. There's $307.11 in court cost, and the attorney's fees is $1,082.81.
All right. So the court will grant those amounts. There summary judgment having been filed. The the defendant did not appear for the hearing, but has not presented information that would present a genuine issue of material fact for decision by the jury. Therefore, the court is going to grant the motion for summary judgment in the amount of $10,578.09 in principal, $307.11 in court costs, and $1,082.82 in attorney's fees. And we'll go ahead and get that order out to you.
Thank you.
All right, thank you. All right, the next case is LVNV Funding LLC versus Charity Grant.
Vinita Gandhi on behalf of defendant.
You're here on behalf of Ms. Grant?
Yes.
All
I
right.
filed a motion to withdraw as counsel, and I believe the court has scheduled this hearing based on that motion.
Yeah, here's the problem. Folks are taking on these, the defense of these cases, these um, debt cases. And then before we can resolve them, they're just leaving the cases. And so I got a bunch of things where defendants don't know they're supposed to respond, and then we're kind of stuck. So is Miss Grant, like, is she aware of what's going on? She's not present.
She's not present. We've been trying to reach her since 2024 to resolve this matter, this account, and she has been unresponsive, which is why my firm and I had to drop representation. We have sent her the motion for summary judgment, a copy of that. We have sent her hearing notices, and we have submitted 4.3 notices to Ms. Grant, letting her know. She was also informed that she was supposed to be here today, and she was sent in all of the instructions as well. I'm not sure why Ms. Grant is not here, but I am also not unable to reach her.
All right, so that is a basis, that's enough of a basis to grant your motion to withdraw.
Thank you, Your Honor.
Because we also sent notice from the court and she's not present. All right, thank you. You may be excused. We have a proposed order, is my understanding.
Yes, I have submitted a proposed order.
Okay, thank you.
All right, thank you.
You're welcome. Okay, the next case is Crown Asset Management versus Mac Freeman.
Yes, thank you, Your Honor. May it please the court. Joe Pippin here for plaintiff on that one as well, Your Honor.
All right, Mr. Freeman, I thought I saw Mac Freeman. So, Mr. Freeman, I need to see you and hear you. Okay, Crown Asset Management versus Mac Freeman. Okay. He might be having technical difficulties, Mr. Pippin, if you just give me a minute.
Yes, ma'am.
Nellie Perkins, I'm sorry, as administrator versus Dorleen Foster as South Atlanta Vascular.
If you're calling position 5, Judge, that case is reset.
Okay, thank you. Okay, the next case is Credit Acceptance Corp versus Kimberly Chandler. Anyone here on behalf of Credit Acceptance Corp?
Yes, good morning, Your Honor. Jasmine, well, good afternoon now. Good afternoon, Judge. Jasmine Shorter here for the plaintiff.
Okay. And Ms. Chandler?
Yes, ma'am, I'm here.
All right. All right, and then this is just a suit on account or on contract.
Yes, this is a suit on breach of contract, Judge, and I do apologize. I have not had an opportunity to conference with the defendant in this case. I don't know if Ms. Chandler has spoken with anyone from our office, but I'll be happy to conference. Okay, I would be happy to pre-trial with her, Judge, if you would like to, if we can go into a breakout room.
Okay. All right. Ms. Chandler, would you like to go into a breakout room with Ms. Shorter?
Yes, that's fine.
Okay, thank you. All right, when you all are ready to come out, if you activate your screen, the same mechanism you used to go in, the invitation, there'll also be a breakout, a way to leave the breakout room and to return to the main room, okay?
Okay.
All right. You'll see the invitation pop up in a moment.
Okay.
All right, there you go. All right, I'm still trying to reach Mr. Freeman, Mac Freeman.
I'll say I'm ready whenever the court's ready.
I'm ready. I see Mr. Freeman. I don't want to ignore him because he did come to court, but the fact is I can't hear from him.
Well, the only thing I would say, Judge, and I don't mind waiting a few minutes, but the issue is that he never responded. This is on plaintiff's motion for summary judgment, and Mr. Freeman never responded to the request for admission of fact back on August 20th, 25. And Georgia courts have held, and as well as the statute 91136, that responses. I mean.
You mean like I just did in the members case?
Yes.
Okay. So, all right. I'm sorry.
Exactly, Judge. I don't need to repeat exactly, Your Honor.
This is Crown Asset Management versus Mac Freeman. For the record, because we're recording and it's live streaming, I've attempted to get Mr. Freeman's attention several times. He's present, as I can see his name on the screen. I've sent a prompt to start video. I've sent a prompt to start audio. And I've gone through several other cases while waiting for Mr. Freeman to respond. So this is case 2025 CV 02198. Mr. Joe Pippin is here on behalf of Crown Asset Management. And Mr. Freeman, who is representing himself, there is a name on the screen, Mac Freeman, but I have made several attempts to call him, contact him through technology, and I have not been able to reach him. So, Mr. Pippin, go ahead.
Thank you, Your Honor. May it please the court. Joe Pippin here for plaintiff. Judge, this action was brought due to the outstanding balance on a personal loan that Mr. Freeman had. I just had it here. The defendant took out a personal loan for $12,000 back on June 25th of 2022. Payments of $334.46 were supposed to be made for 60 consecutive months. At least one payment was made, but then payments did cease. Subsequently, this action was filed. The defendant did file I would argue, a boilerplate answer, general denial, raising a lot of legal defenses that, I would respectfully argue are not applicable, latches, unclean hands, things of that nature. On August 20th of 2025, the defendant was certified mail sent a request for admissions, certified and regular mail sent to defendant's home address. There's no knowledge that the defendant has any change of address after being served at the outset of this case. There was no response to the plaintiff's request for admissions. There have been no payments or other communications from Mr. Freeman since that time. There's no genuine issue of material fact either that the defendant had this loan, received the funds, made at least one payment, but then ceased payments. And there's been no evidence presented that the amount the plaintiff alleges owing is different or has been paid. And the amount that plaintiff seeks in its motion is the principal amount of $11,447.16. Showing $1,048.67 in contractual interest on the loan and $273 in court costs, no attorney's fees. That would be the plaintiff's motion for summary judgment, Your Honor. Thank you.
All right. So, as I've stated, Mr. Freeman was called before the court. While I can see, I see a name Mac Freeman on the screen, I've attempted through several means. I called the case several times. I have sent a prompt to unmute. I have sent a prompt to play your video. Mr. Freeman has not made a meaningful appearance before the court. This is a motion for summary judgment. Request for production, request for permission for admission were sent and were not responded to. They're deemed accepted at this time. And since no genuine issue of material fact exists for a trial by the trier of fact, $11,447.16 in principal, $1,048.67 in interest, and $273 in court costs, and no attorney's fees are sought. These amounts will be granted at this time.
Thank you, Your Honor. And one more note, I guess Ms. Shorter has left. I did thank her in the chat, but it's very kind of her on that Mr. King garnishment case. And I know that's reset, but just for clarification, she looked while we were waiting and found that there was a 2024 garnishment out of Clayton County, and that was the confusion, but we'll make sure.
Okay.
Yes,
well,
ma'am.
Thank you. I'll tell her you said thank you, and thank y'all, because when we help each other, it does go a lot smoother.
Yes, she was intrigued too. So yes, ma'am.
The gentleman kept very good records, and so I knew something was going on, that maybe we were dealing with more than one.
Yes, ma'am.
So that works, and I will definitely let her know. Thank you,
Yeah,
Mr.
that's very, very kind of her. I appreciate the court's time, and if it's okay to be excused, then I'll see you next time, Judge.
Yes, sir. Thank you.
Thank you. Have a good day.
You too. All right, the next case that Miss Shorter and Miss Chandler are speaking, the next case is Wells Fargo Bank versus Demina Rogers. I'm sorry.
Good afternoon, Your Honor. Alex Capers on behalf of the plaintiff.
Good afternoon again, Ms. Capers. Demina Rogers. Okay, so there's Miss Rogers. All right, so this is a Wells Fargo a suit on account on the contract. A motion for summary judgment has been filed for the contract damages. So the complaint was filed. Ms. Rogers was personally served. Ms. Rogers filed an answer, and then the plaintiff filed the motion for summary judgment. Okay, so go ahead, Ms. Capers, and then I'll hear from Ms. Rogers.
Yes, Your Honor. So that's the procedural history. And factually, the answer that was filed just states that the defendant lacks sufficient knowledge and information to admit or deny the allegations of the complaint. Therefore, we filed a motion for summary judgment. This is a suit for the balance owed on a credit card account. And there's no genuine issue of material fact presented by the defendant. The outstanding balance owed is $11,225.73. There's court costs of $307.11. And our client has chosen in this particular matter to cap the statutory attorney's fees at $800. So those are the amounts that we are seeking, and there has not been a response to the motion for summary judgment filed that I'm aware of.
All righty. All right, Ms. Rogers. You have to unmute, ma'am. Yeah.
Hello? Okay.
Yes, ma'am.
I was in contact with Wells Fargo.
Okay, repeat that. I'm sorry, I didn't hear you.
Okay, I was in contact. I called them to let them know that I had lost my secondary income, and that's why I was unable to make payments, and I also got sick as well. However, I am currently started a new job as a first-year teacher, and I am trying to see what are my options as far as paying them back or removing some of the interest, or as well as what is it called, the late fees.
Okay.
I'm not sure how it goes. It's my first time doing this, but due to the fact of illness and then my income at the current time still is hardship. So I don't know how to explain it, but this is the best way I can.
I get it. So hardship is really not a defense to owing a contract.
Okay.
Ms. Capers her client has instructed her to come and seek a judgment in this case. So she's presented that. She's filed the motion for summary judgment. You haven't presented anything with respect to a legal argument that would allow the court to deny the motion for summary judgment. So Ms. Caper's client is entitled to having the motion for summary judgment granted. And she's explained the amounts. You're always able to, pre-judgment or post-judgment, speak with the company that you owe in order to see if a payment plan is something that they will agree to. It's not something I can make them agree to. I can only give the judgment. But you always have the option of reaching out to them to set up a structured payment plan so that you know how much you're going to pay every month and they know how much they're going to receive every month. Otherwise, they have the right to pursue whatever legal means through the state of Georgia in making collection upon the judgment. And that would include a garnishment, which you would have no control over how much money comes out of your account. Am I correct, Ms. Capers?
Yes, that is correct. And I can give her our phone number so that she could contact us to possibly set something up like that to avoid any type of post-judgment collection activity.
I would like to do that, please.
Okay, so Ms. Capers is going to chat to you their phone number and contact information. Any person that you need to contact, or if it's just whoever you speak to, you can speak to about the information. She's going to chat.
Sorry, I'm sorry.
No problem.
Would this be considered a post-judgment? I'm so ignorant to this process.
So today, so anything prior to today is pre-judgment.
Okay.
Today would be the date of the judgment, or when I sign the order, whenever I sign the order and send it out. Then anything after that is post-judgment.
Got you.
Okay.
Sure. Okay. So can I speak with her now? I'm not sure.
Ms. Capers, it's up to you.
Yes, she can call our office now. As soon as this hearing is concluded, she can give our office a call. We have several people on the phones. I can also give her an email address.
Okay.
I do have another hearing in just an hour. So
okay. So Ms. Rogers, if you go to your chat function, if you see, you should see a box with chat somewhere on your screen, and with a red number with a white. Okay. Click on that, and you should have the information from Ms. Capers. Ms. Capers, you've presented your motion for summary judgment. There being nothing in opposition that the court can consider to establish that there's a genuine issue of material fact. The court is going to grant the amount of $11,225.73 in principal, $307.11 in court costs, and $800 capped per the client's instructions for attorney's fees. And that total, the court is going to grant that in judgment. And if you will present the order, once we get the order and sign it, we will give a copy to Ms. Rogers and a copy to Ms. Capers for your client.
And Your Honor, a proposed order was filed in this case, so
yes, ma'am.
Should be one on the docket.
That's it.
What is a proposed order? I'm so ignorant. Oh my gosh.
Okay, so Ms. Rogers, this is in a nutshell. This is what happens.
Okay.
If you fail to pay a debt, they will sue you. They will serve you with a summons and complaint. You have 30 days to answer. If your answer does not have legal defenses, then they will pursue a motion for summary judgment saying that there's no controversy, because what we're saying.
What would be legal defenses on my behalf as far as what I explained previously, my illness, and then
because your illness is not their fault.
Okay.
Your illness is your illness, or any hardship or loss of job. Those are hardships on your part, but you took out a loan or you used a credit card. And at the time, you may have had the ability to pay, but your loss of the ability to pay is not their fault. And so, they can't bear they cannot bear that burden.
Okay. So I guess I will have to talk to them and see how I can work things out.
Yes, ma'am. You can call them and see if you can set something up now.
Okay.
All right. All right.
Thank you,
You
Your
all,
Honor.
I
And
don't
before
see the
logging off, I just want
information.
to make sure. Okay, yes, that's what I was going to say. I just want to
Okay.
make sure she has the information. So,
okay, yeah, don't leave where you have
do
written
you
down.
do you see it, Miss Rogers?
What am I looking for in particular?
When you click on
Me.
chat,
I am on chat.
And then I sent you our phone number and email address.
I'm not seeing that. I see homes at Cope of Orlando. That's what I'm seeing in the chat.
no, look up at the top.
At the top. I'm so
Do
sorry.
you see some boxes at the top? One should say everyone, one should
Yes.
say Alex Capers. Click on
Okay,
Alex
okay,
Capers.
okay. Got you. Thank you.
Thank
4,
you.
6, 9.
Okay. So the next case that's coming up while Ms. Rogers is writing that down. The next case is I want to make sure I got the right one. Ollie McMillan versus Horace McLean.
Good afternoon, Judge. How are you?
Good afternoon.
Mary Page Gray for the plaintiff, Ms. McMillan. We're here because I filed a motion to withdraw. Last year in June, we received a final judgment. After that, we started collection attempts, and then we had not heard from Ms. McMillan since July of last year. Unbelievably, she answered my call this morning. So she did say she had gotten everything. She just didn't want to pursue the case any further. So if you would, I mean, she didn't object to our withdrawal notice. So if you would like to enter that, I think that's an option. Or now that she's told us she doesn't want to pursue collection, I mean, the case is pretty much done from our perspective. So.
Okay. Well, she may change her mind. I'll go ahead and enter the withdrawal motion, the order.
Okay, thank you for that. I appreciate it. And I'll
All
let
right,
her
thank
know.
you.
She received everything, but I'll let her know that too.
Okay, thank you so
Thank
much.
you. May I be excused?
Yes, ma'am.
Thank you.
All right, and the next case is Lakeisha Jackson versus Anthony Jackson and Bunzel Distribution Leasing.
Continued.
Okay. All right. All right, so that's the last case on the 11 o'clock calendar. It is now 12:29. I still see, I think Ms. Rogers is still writing stuff down. Ms. Capers, that was her last case. Who is Anne Marie Russell? Oh, court reporter. Okay, so thank you, Ms. Russell. So at this time, the court is going to take a recess until the 1 p.m. calendar, and then we'll return. Thank you.
Judge, if the parties that are in the breakout room come back before 1 p.m., do you want me to just ask them?
I forgot about them.
And Your Honor, may I be excused? This is Attorney Alex Capers.
Yes, ma'am. Yeah, Miss
just have them hold until 1 o'clock and we can take care of them first.
Yeah, that works.
Okay. Alrighty.
Thank you.
Ms. Shorter, I did receive the consent order that you emailed. When judge returns to the bench at 1, she'll take this case up first.
Okay, perfect. Thank you.
Hello? Hello?
Court is resuming at 1, Mr. Freeman.
Oh, okay.
Good afternoon. So we had one case from the 11 o'clock that was went into the breakout room. So do we have an announcement on that, Ms. Shorter?
Yes, Judge, we were able to reach an agreement in that case, and I have emailed the fully executed consent judgment over to Ms. Powell, and she did confirm during the recess that she received it.
All right, so we'll go ahead and get that executed and we'll send it out.
All right, thank you, Judge. That's all my business with the court today. May I be excused?
Yes, ma'am, thank you.
Thank you.
And
All right,
Judge, Mr. Freeman has returned if you'd like to dispose of him.
Mr. Freeman, I kept trying to get you. I couldn't get you to respond, but there was, you failed to respond to certain documents that that the attorney for on behalf of the creditor sent you. Because you failed to respond to the request for admissions, those were deemed admitted. So the motion for summary judgment was granted.
Okay.
Now, this is what I say. You can always call the creditor to determine whether you can set up a payment plan to avoid things that are a little bit more drastic, like a garnishment. So you may want to do that.
Okay. Yes, we've already. I'm working with a group, and they've already reached out to them, and I guess it was kind of basing on the decision from you today.
Okay. All right. So just continue to work with them and talk to the creditor.
Okay.
And you'll get a copy of my decision.
Thank you.
All right. Thank you, sir. All right. This is the 1 p.m. calendar. This is Ada Molina Costin Cruz versus Diaris Nellums, Peachtree Truck Leasing versus ProMed Imaging and Unified Medical. But essentially, the case took a turn because at the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right, and so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right, so Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case, but I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to, I guess, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. So I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
All right, don't know what that was.
Go ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out And we asked them what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolves all the prior behavior and sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further, but I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's exhibit D to that motion. It's my affidavit of fees.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it'd be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting. You got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case someone who's acting on behalf of the parties, if Ms. Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really, that's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced. whether you use an artificial intelligence application or not, there are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers, and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston-Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am. And then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file. If you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that that is an excessive amount. So $25,498.08. That's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, I mean, we would have no reason to oppose that, and I'm happy to get on a call with counsel once this hearing wraps as well.
Here's my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OCGA 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. I mean, they filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why. She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Can you see my screen, Your Honor?
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to.
I have December 14th, 2023.
Right, in Gwinnett County, totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, I don't know what to do at this point. That's all. The only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915.14 or because of the contumacious conduct to the court. But I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case, we had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if if the discovery is deemed admitted, and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are two police reports or two incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those omissions. You know, I would want to move to do that.
Well, that's already been done.
This is the issue that I'm having, though. Y'all have, I don't know how you got into the case, Ms. Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time, because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was okay. It was August, because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, I mean, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. I mean, this stuff was all briefed and is in front of you and was briefed back in September and August and October.
The issue is, though, that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed, because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing argument from Ms. Middleton.
Again, Your Honor, we do not disagree with the procedural history of this case. We were, I guess we started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed, and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical
exhibits
records
filed with the, yeah.
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Miss Middleton. She's only been in the case for a couple months, but at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. In knowing the procedural history of the case, at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support and give the court a basis for the decision to overturn the fact that the admissions have been deemed admitted.
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have. Not against my clients, but if that's of concern.
Is this a first filing? This is not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case. And I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the, I'm not a superior court judge, so I can't balance the equities as it were. But I do have to consider, fairness, and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as to Peachtree Truck Leasing Company.
Peachtree Truck Leasing, right.
Right, which we were going to take up in August and then we never got to it.
Yeah. So what we had talked about was the default was in, and then we were talking about whether a damages hearing would prejudice the remaining parties in the case because of the information that had to be presented during the damages hearing. And so that's sort of where we left it before all of the issues with the briefs.
Right, and so you already ruled that we couldn't have a damages hearing because there was still one defendant that wasn't in default. This is a slightly different issue because I'm asking you to open the default and set aside the judgment as to liability as to Peachtree Truck Leasing altogether because they're an improper party in the first place. And I told Mr. Gillespie, but I'll tell Ms. Middleton now. I know who the proper party is. I've put it on all the briefs. And all I'm asking is that we just swap out the parties so we get the right entity in here. I'm not trying to hide the ball or extinguish any claims or anything. We're just trying to get the proper parties in. And Mr. Gillespie was, I guess, holding on to his default judgment that he'd gotten as to this Peachtree Truck Leasing, which again is not a proper party, and we didn't want to agree to lose that. I don't think the plaintiff is prejudiced at all by getting the correct defendant in here and litigating on the merits since we already have Mr. Nellums has not been in default at any point. But that's the issue there. And again, maybe Ms. Middleton.
Okay, let me ask this. Do you also represent the proper entity?
I do, yes. So there won't be any issue with that.
All right.
Yeah.
Yeah, we would not want to keep the wrong entity in, so we'd have no objection to that.
Okay.
Okay.
I can put that in a proposed order too then if you want.
Yeah, please do.
All right. All right, I think that was the only other thing on the table.
All righty. Thank you all.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.